All right, council, good morning. We're on the record now in homeowners versus churches, Comfort Care, Northern Michigan. This is case number 2319353. And is it Dunas or how do I pronounce your name, council for homeowners?
Thank you, Judge. It's Dwayne.
Duenas, okay, very good, thank you. So you're appearing on behalf of homeowners this morning?
Yes, on behalf of the appellant, yes.
Thank you. And Mr. Connolly, who are you appearing on behalf of?
Good morning, Your Honor. Yes, for the record, Mark Connolly on behalf of Churches & Co. or Comfort Care.
Okay, very good. All right, this is the date and time set for oral argument in this appeal. I have had a chance to review the briefs of the parties in this case, as well as the file. And so this is the date and time set for oral argument. Mr. Duenas, is there anything that you wanted to present today here by way of oral argument in addition to what was presented in your written filings?
Yes, Your Honor. I just wanted to address the call. I'm not going to go over my entire brief, but I will like to point out some things for you that I think are important for the purposes of the appeal. First, there is no question that, and no dispute, that the fee schedule under 531.57 applies to this case. This is an auto accident that happened in May 30th, 2022. So the issue is how do we apply the fee schedule, not whether it applies, because there's no question for that. When you look at the end result of the DIF's ruling, basically what you have with the evidence we have before us is there is no practical effect to that fee schedule, because the basis of the rates they used was an amount that was 200% higher than they normally charge based on exhibits D and G provided to the court. So the issues going through the DIF's analysis, you have to look at there's three different levels for the fee schedule. First, is there a Medicare rate that applied? Two was what's the 2019 charge master? And three, you have to always have a determination that whatever's charged is not an amount that exceeds the amount charged for cases not involving insurance. Well, in this case, Comfort Care argued to DIFs, and DIFs accepted the fact that there was no Medicare rate that was payable. Now, the interesting thing that I wanted to point out to the court is that pages 8 and 16, I believe, of the brief, 8 and 14 of Comfort Care's brief, Comfort Care indicates that, and I'll read it to the court. It is it tries to differentiate itself from this Ralston company that functioned before, and it indicates that it is a certified company under. Comfort Care is accredited by the ACHC, Accredited Commission for Healthcare, and is a Medicare certified home health agency. So just by that statement, by that admission in its brief, there is a Medicare rate that should have been considered. Now, and they get into a lot of detail about the rate and how the analysis should be done, but there's no question they're Medicare certified. Comfort Care only provides this type of care, and just by the fact that they're Medicare certified, we see that the standard, the DIF's appeal, was erroneous because it wasn't based on competent evidence. It was the first step of DIF's was there was no Medicare rate payable. So how can you be a Medicare certified home health agency and there is no Medicare rate payable for your home health agency? It doesn't make any sense to say that in the same breath. And the problem is what you have the argument, Comfort Care is using that argument to undermine the argument that it wasn't business in 2019. And I'll get to that part too. There's a lot of evidence that was presented in these briefs that DIFs should have discussed But in particular, DIPS should have said, hey, you're accredited, or no, Comfort Care was obligated under 3157 to certify that it was true when they said there was no Medicare rate payable. They had to tell DIPS we're Medicare certified. So their rate should have been on the table and should have been considered by DIPS. So that I don't even know that I need to get further into that argument, because we provided information that there was payable rates, and they argued the rate would be different under a Medicare analysis. But it doesn't matter. The point is that we're here to say, did DIPS commit error? And DIPS did commit error because the first thing it said was there was no Medicare rate. So we both talk about Medicare rates and we argue that, and that's another issue. But so that issue, I think, is pretty clear from the brief. The second issue is that whether or not there was a charge master in place in January 1st, 2019. Now, that's another issue that DIPS just passed on. And DIPS said there was no charge master. They said they weren't in business and moved on from it. There was no discussion about the fact that Comfort Care was actually in business. It was incorporated, and the Churches and Company was incorporated, was in business at the time in 2019. There's no discussion about when it became Comfort Care, how it got into its rates, when the rate sheet was put in place, and most importantly, Judge, Comfort Care is a franchise operation. So we're talking about Comfort Care, not Northern Michigan. Comfort Care as an entity is a franchise operation, meaning that if I supplied it to the court, there's a list of multiple different Comfort Care franchisees throughout the state that was never even discussed with DIPS. Now this is evidence that, is it material evidence? Yeah, it's material evidence because they're doing the same type of work for the same type of company, for same franchisor. So why under the fee schedule, DIPS did not know that it was a franchise or in place and there are multiple other franchisees, and DIPS should have the option to consider those pricings. Because it talks about whether the person was in place, whether, and what happens a lot with the fee schedule. And like it or not, we do have this fee schedule. This is just part of the 2019 amendments. From 2019 on, we're faced with it. So what a lot of people do when or a lot of companies do when they try to avoid the application to the fee schedule is, one, they pick a CPT code, and they don't talk about the treatment. They talk about the CPT code, and that is not payable by Medicare. The statute 3157-2 talks about treatment paid by Medicare. We already know it is payable because they're certified by Medicare. And we also talked about the different rates and the arguments we have. But what they do is they give you a CPT code, so you're not looking at you're not looking at treatment, you're looking at a specific code. And a lot of times they upcode it or code it wrong to manipulate whether or not Medicare pays for this amount. And I've seen that in issues with electrical stimulation and things like that. I have other arguments like that going on. The issue here is the treatment is paid by Medicare. Two, this company was in business in 2019, or franchisees similar to it were in place. You could look at the Ralston company that was in place, and basically all Comfort Care did is take over that business. And the Ralston company, they argue, well, we're certified by Medicare, so we charge more. Well, we don't even know your rates. We don't know the Ralston rates. None of this was able to even argued or disclosed to DIPS. DIPS doesn't know about the franchisor. DIPS didn't know about the other charges out there for exact same rates by other franchisees or other exact same care. Didn't know about the Ralston company. Didn't get a chance to have that disclosed. All was said was, we didn't work in 2019, and there's no information considered. So how is that a proper record for DIPS to consider? I mean, DIPS needs to know this, and DIPS needs to make this charge. We don't need to be looking at it now and looking back and say it was perfectly fine for DIPS to ignore both of these issues, because that's not our point as an appellate. Whether or not there's material evidence they should have had in front of them is the question. And then the last piece is the overall mandate in 3157 is that the charge must not exceed the amount the person customarily charges for treatment or training in cases that do not involve insurance. And we have evidence before us. In 2019, there was a $27 charge. In 2020, there was a $30 charge based on their own rate sheet. And then the charge that they start with, in this case, is $61. And that's a manipulation. That's a typical thing that's done with the fee schedule. Is what they do is there's a lot of shell games going on with people reincorporating, starting new businesses. Then they have this new rate sheet that starts after 2019. Then they charge something in the area of 60s. So then you get a reduction to what? Just about what they charged before. So it's a way of sidestepping the fee schedule. And it's very clear in this case. So now we have a company that would charge $30, now charges $61, so it gets reduced to $35. And then they say, therefore, I'm getting $35 an hour for this care. And that's completely an opposite of what the fee schedule is supposed to be doing. So I briefed it all. If you have any questions, Judge, I'd like to, gladly answer them for you. But I'm not going to read my brief over and over again, unless you want.
Okay. No, that's okay. I don't have any questions. It was well briefed. Your brief was very clear, as well as your arguments here today. I will give you a chance after Mr. Connolly's done to respond to anything, since you are the appellant in this case. Mr. Connolly, any oral argument on behalf of your client?
Thank you, Your Honor, and I will certainly be brief, as I would ask the court to rely on what we put in our brief. I believe we were concise and kind of gave you the full logical flow of where we got to, where we got to in this case. A couple of things that I do want to point out. I mean, as we laid out in the brief, I'll start with, this charge master document. I mean, it's very clear, and we provided, a portion of the franchisee document that says that yes, Comfort Care is a bigger company. They have franchisees out there, but it's very clear that they allow them to make up their own, pricings based on the things that you would think a franchisor would tell their franchisees to base their pricings on, where you are, the skills needed, and all those things. So that certainly makes sense, and it's right in those documents that we provided to the court. In terms of Mr. Church's company right now, as we also laid out, he was doing contractor work before 2019. He was not in home health at all until after January of 2019, as we pointed out in our brief. So he did not have a charge master, and there isn't a charge master. There is suggestions for these people to, for these franchisees to follow, but it's by no means something that's concrete that they have to do. And again, I think we kind of laid that out in our brief. Counsel was just then making arguments about the $27, and I think he said $30 an hour as prior pricing. Well, but they stand here before this court and are asking for $17 an hour. As we said in our brief, I mean, I'm certainly not here to argue that that this doesn't fall under the reforms and that we have to look at 3157, but there's still a requirement in the statute for reasonableness. And that is kind of like the catch-all that the court and that DIFS looked at, or the court needs to look at, and that DIFS was looking at. This just needs to be reasonable. $17 an hour is by no means in 2023 a reasonable amount for the skilled care that the Churches and Co. is providing to this patient, Mr. Dings, as we laid out in our brief. I mean, this isn't just a broken wrist or a broken leg or something like this. I mean, this is a very significant injury that Mr. Dings suffered, and there's no dispute that his physicians are calling for 24-hour care. That is, clearly that's something that is very significant that he needs. So, and again, I just asked the court to follow our brief. I believe it's logical, and it lays out why, what DIFS ruled is appropriate. And also when there's talk about the CPT codes, as we pointed out, you have to look at that. And those are per visit, 1 unit. I mean, one per visit is considered only 6 hours. Again, which is not commiserate with what is going on here and what Mr. Dings needs. We just asked the court to rely on our brief, and again, we'd ask that they uphold DIF's ruling, as we believe it's reasonable and is called for under the law.
Okay, thank you. Mr. Duenas, any response argument that you wanted to make?
Just 3 quick ones. Is one, if you notice, Judge, they didn't rebut and didn't argue the issue about there being a Medicare rate and DIF's not considering it. They have a Medicare rate. They told DIF's they didn't. That's a problem. That's an error. That's an error by DIF's not considering that information. Number 2, the issue of the charge master is what Mr. Connolly just argued, was that there was suggestions to follow by the franchisor for rates. It's not mandatory, but there is suggestions by Comfort Care, the franchisor. So there is a charge master and recommended rates by the franchisor. It didn't say they had to follow it. But why wouldn't DIF's be able to consider that? Or why wouldn't DIF's be able to, and I did in my exhibit C is a beginning list from Laura of the different Comfort Cares out there. And we're talking about in Vanderbilt, Michigan, Flint, Michigan, Gaylord, Michigan, like we have here, Bloomfield Hills, Novi, Ypsilanti. They're all over the state. Why shouldn't DIF's had considered that material evidence, that what their charges are throughout the state in 2019 and why that would apply, and let DIF's decide whether or not it should apply, because, and that's their decision, what they should have done. And then finally, he says, well, we're asking for $17 an hour to be paid and not the $30. That's what the fee schedule is supposed to do. That's the point of it all. There's this trade-off, and whoever's brilliant mind decided to do this no-fault amendment, it wasn't our choice. It was done by our legislator and how they did it. And they decided that this was the trade-off, that you would get a fee schedule and limited attendant care and replace for a few other things. This is how the statutory scheme was devised. It's not for companies to come in and skirt around it and provide information, a little information here to DIF's, or no information to DIF's, no Medicare rate, no 2019 rates. I mean, what kind of record do we have here? All this stuff is competent material. If I'm arguing to you and I was arguing it, I'd let you make the decision whether I'm out of my mind or I'm correct. But that's for you to decide as a judge. If I was before you, this should have been able to decide this. And because it didn't, it has a record that is based on false information and limited information purposely. So there is no question that the standard we're talking about, was it authorized by law for DIF's to say, not consider what Comfort Care may charge to people without insurance? No, because that wasn't done. And that was not authorized by law because the statute mandates that they consider that. 2, is the evidence competent and material? No. There was no evidence of the Medicare rate that clearly is being charged by the Medicare certified Comfort Care in this case. They said they weren't paid by Medicare. It wasn't covered by Medicare. No Medicare rate was considered at all. The competent evidence, was the competent evidence, material evidence considered about the franchisee amounts, about the other companies in business, about the recommended amounts from Comfort Care, the franchisor? No. In fact, that was never even discussed with DIF's. So DIF's didn't have that information. And by the way, the worst part, judges, under 3157, Comfort Care was obligated to certify everything it said to DIF's was true and correct, including that I'm a Medicare certified company that doesn't get Medicare payments. And it's clearly false. So this should be sent back to DIF's, and it should be, hey, listen, consider these things. 1, consider the Medicare. 2, consider look at this information about the 2019. And 3, look at what is his rate for non-insurance cases, or Comfort Care's rate, not his rate. So thank you, Judge. Thanks for your time, but I think it's well briefed. I think we've got a couple clear issues that need to go back to DIPS and be readdressed.
Your Honor, if I may, very briefly.
Sure. Yes.
I just want to point out that as counsel keeps talking about, this Medicare rate and whether it was considered, we went through that pretty extensively in our brief. I would just ask the court to reread through that and through the logical kind of way we went through it, the numbers came out higher. So again, as I wrote in here, I mean, we know that it still needs to be reasonable. And I went through extensively how Medicare does this with the HHPPS or the other fee for service way. And so I just asked the court again to go through that and rely on what we've put there.
Okay, very good. Thanks to both counsel for the briefing and your arguments here this morning. The court is going to issue a written opinion on this. I'll get that out to the parties as quickly as I can. And we'll go from there. Anything else for the record today, Mr. Duenas?
No, Your Honor, I just want to thank you for accommodating us by Zoom. I appreciate that. But nothing else.
Sure, absolutely. Mr. Connolly, anything further from the record?
Nothing. Nothing, Your Honor. I would reiterate that same sentiment. Thanks for letting us do it this way, and thanks for the opportunity this morning.
Okay, very good. Thank you. All parties are free to disconnect at this time.
Have a great day. Thanks, Judge.